It's a pleasure to follow the honourable gentleman who I think made a very powerful contribution, not only on Amendment 3 and Amendment 6, but right the way through the comments that he had to make. And I think it is a testament to this House that almost every contribution thus far has been on the right track, has exuded the compassion that we want to show as a country, and no more so than the Right Honourable Lady, the Member for Staffordshire Moorlands. I was greatly enthralled by what she had to say, and I agree with the sentiments that she expressed. Madam Deputy Speaker, on Amendment 5, I know the Government have engaged financial privilege, and with that they are asking this House to disagree on the financial implications of the proof of status document, and no other reason. Engaging financial privilege means that is the rationale for asking us to disagree with Amendment 5. And I would ask the Minister to reflect in his comments, if the only issue is finance, if he recognises that a biometric residence permit, for example, is available for less than £20, if that is the issue, then I hope that should there be a subsequent attempt in the other place to insert a similar amendment without subsection 2, that Government will agree, because I think the argument is not only about digitalisation, about the difficulties associated with online information solely, and the desire that people sincerely have to hold a permit outlining their status, then it is something that the Government should engage with thoughtfully. Madam Deputy Speaker, I have spoken quite a number of occasions in this House around the issue of indefinite detention. The Minister knows that I have quite a rigid position on indefinite detention. I was more keenly in support of amendments that were previously before this House that at least gave the opportunity for an extension of an additional 28 days. I thought that gave Government more latitude in exceptional circumstances. But I still believe that indefinite detention is immoral. It is unjustified. I haven't heard justifiable rationale for it yet. It is unjustifiable. No one has. We hear about the difficult stories, the hard stories. We hear about the excessive cases. If someone breaks the law in this country, then arrest them and put them through due process. If somebody is going through an immigration application process, don't put them in custody. Don't give them any sense of how long that process will be. Treat them like we would wish to be treated. Treat them humanly and humanely. Madam Deputy Speaker, I do want to touch on Amendment 9 for the remainder of my speech. And I'm pleased to speak in support of Amendment 9, which was supported in the other place through a powerful speech of my colleague Lord Morrow, who as a private member in the Northern Ireland Assembly brought through our seminal Human Traffic and Exploitation Act. And for those that talk about the United Kingdom Government bringing forward modern slavery legislation being the best in the world, it started in Northern Ireland first, and we are proud of that record. We were the first devolved administration to bring forward our legislation, and we were proud for what was achieved at that point. And I did listen very carefully to the Minister in his opening remarks. I was grateful for a telephone conversation we had earlier today and for the subsequent correspondence that he has shared. And I think he knows from the tenor of contributions from the Right Honourable Member for Chingford and Wood Green and others that there is still work to be done on Amendment 9. There is still work to be done on changing the terms of the guidance available. And so I do recognise the development that he has brought forward this afternoon. But I'm still not sure that from what we've heard this evening, we should be convinced that it's good enough reason for this House to agree with the Government and disagreeing with the Lord's Amendment. The presenting challenge is that any trafficked person from an EEA territory who arrives in the UK after 31st of December will only have one long-term route to recovering discretionary leave to remain, whereas today they have two. While the commitment to automatic consideration is progress, it does not change the fact that the then Government Minister spoke to the DWP Select Committee in 2017 as part of the inquiry and said there must be an exceptional or compelling reason to justify a grant of discretionary leave to remain. And you only have to go through some of the FOIs, and it shouldn't be that difficult to get this information from the Home Office. But you have to go through FOIs to establish that 8 to 9% of applications from those certified as victims of modern slavery inevitably get discretionary leave to remain. That's far too low. Far too low, and something that the government needs to consider. Madam Deputy Speaker, I fail to see why confirmed victims losing their right to recovery through treaty rights will be particularly reassured by the commitment they will automatically be considered for something. Unlike recourse to public funds through their treaty rights is only given in an exceptional situation, that 8 or 9%. The other difficulty with the idea that the introduction of automatic assessment for discretionary leave to remain is an effective replacement to recourse for public funds through treaty rights is the fact that discretionary leave to remain is discretionary. It's not a right. Clause 12 makes it a right. Amendment 9 makes it a right. If a confirmed victim of modern slavery who is an EEA national meets criteria in subsection 2, then their access to leave to remain will no longer be discretionary. And that is what we should strive to achieve, Madam Deputy Speaker.